Sexual harassment in the workplace can be a serious problem. With the explosion of the Me Too movement, sexual harassment was catapulted into the national spotlight by the media, government agencies, and social media. The attention given to workplace sexual harassment has continued to expand, and addressing the issue is paramount to ensuring employees can work in a safe and healthy environment. Additionally, providing a workplace free of harassment is beneficial to the company legally, financially, and socially. Managers and supervisors play an important role in keeping the workplace free from sexual harassment. There are specific steps, duties, and obligations which must be carried out in the effort to maintain a fair, safe, and productive workplace for all employees. This training program will look at the following areas dealing with sexual harassment. Basis of sexual harassment. Definition of sexual harassment. Types of sexual harassment. Sex stereotyping. Transgender rights. Potential victims and harassers. Where can harassment occur? Retaliation. Company policy. Management responsibilities. Investigative process. Harassment is prohibited under federal law and many state laws. Title VII of the Civil Rights Act of 1964 outlawed harassment based on race, color, sex, religion, or national origin. This congressional act also created the Equal Employment Opportunity Commission, or EEOC, to address the various forms of harassment and to enforce the provisions of the act. Since its passage in 1964, many things have changed. With changing social norms, a shift has occurred, resulting in an expanded basis on which harassment can be claimed. In addition to those attributes stated in the original Civil Rights Act of 1964, claims of sexual harassment are now also based on the following: pregnancy, genetic information, sexual orientation, self-identified or perceived sex, gender expression, gender identity, the status of being transgender. According to the EEOC, sexual harassment is defined as any unwelcome sexual advances, requests for sexual favors, and verbal or physical conduct of a sexual nature, when submission to the conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual. Such conduct has the purpose or effect of unreasonably interfering with an individual's work performance, or creating an intimidating, hostile, abusive, or an offensive work environment. Sexual harassment does not have to be severe or pervasive to be unlawful. It is important to understand the different terms used as they relate to a person's sex, gender, and orientation. Let's look at gender identity, gender expression, transgender, sex, and sexual orientation. Gender identity is the personal sense or internal understanding of one's own gender. This may include male, female, a combination of male and female, neither male nor female, a gender different from the person's sex assigned at birth, or transgender. Gender expression usually reflects a person's gender identity, but not always. Gender expression means a person's gender-related appearance or behavior, or the perception of such appearance or behavior, whether stereotypically associated with the person's sex assigned at birth. Transgender is a general term that refers to a person whose gender identity differs from the person's sex at birth. A transgender person may or may not have a gender expression that is different from the social expectations of the sex assigned at birth. Sex includes, but is not limited to, a person's gender, gender identity, and gender expression, pregnancy, childbirth, breastfeeding, medical conditions related to pregnancy, childbirth, or breastfeeding. Sexual orientation is a person's emotional, romantic, or sexual attraction to another person. Types of sexual orientations include, but are not limited to, heterosexuality, homosexuality, bisexuality, pansexuality, and asexuality. Two types of sexual harassment are generally recognized. They are called quid pro quo and hostile work environment. Abusive conduct is another type of harassment which many states are incorporating into their sexual harassment training requirements. Quid pro quo. This phrase basically means something for something. This type of harassment occurs when a person with authority to undertake or recommend employment actions, such as raises, promotions, or transfers, offers to do so for an employee for some sexual favor. Harassment can also occur when one is passed over for promotion, not given a pay increase, or denied a transfer because they would not agree to the sexual favor. This type of harassment is more easily identified and often happens between a supervisor and employee. Most sexual harassment cases are classified as hostile work environments. Harassment occurs when any comment or conduct based on sex, sexual orientation, gender, sexually oriented material, or other offensive material unreasonably interferes with an employee's work and is unwelcome, severe, or pervasive. The comments or conduct are also considered harassment if they create a work environment that is intimidating, hostile, or offensive. Single or isolated incidents of sexual misconduct generally do not create an environment that is considered hostile. A hostile environment claim usually requires proof of a pattern of offensive conduct. The more severe the harassment, though, the less need to show a repetitive pattern. To be considered unwelcome, severe, or pervasive enough to constitute sexual harassment, the activity must also be serious enough that a reasonable person would find it offensive. Hostile work environment sexual harassment includes, but is not limited to, displays or publications of a sexual nature anywhere in the workplace, like pictures, calendars, magazines, and websites. Staring or leering in a suggestive manner. Telling sexual or offensive jokes, or making sexual gestures. Sending sexually related material via email, letters, or notes. Touching, pinching, grabbing, patting, kissing, and brushing against someone. Another form of harassment which can occur is known as abusive conduct. This type of harassment is very similar to hostile work environments and is often classified as such. In recent years, this type of harassment has become identified as occurring more and more in work settings. Some states now require employers to incorporate abusive conduct training into their sexual harassment training programs. Abusive conduct is defined as conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Abusive conduct may include repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, and epithets. Verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. A single act does not constitute abusive conduct unless especially severe and egregious. Sex stereotyping occurs when someone's personality or actions are considered inappropriate based on preconceived ideas and thoughts on how they should look or act. Harassing someone based on such preconceived notions is sexual harassment. Harassing someone for performing job duties that historically or generally are performed by someone of a different sex is also considered sexual harassment. Laws at both the federal and state level are constantly changing and evolving. In 2020, the U.S. Supreme Court ruled the Civil Rights Act of 1964 applies to discrimination based on sexual orientation and gender identity. It is important to always keep up to date with current laws and ensure company policies and procedures do not provide avenues for sexual harassment to occur based on transgender issues. Some areas to be aware of include the following. Interviews. When conducting interviews, employers can inquire about an employee's work history and for personal references, as well as other non-discriminatory questions. Employers cannot ask questions designed to detect a person's gender identity or sexual orientation. Employees have the right to use a restroom or locker room which corresponds to their gender identity. Whenever possible, an employer should provide an easily accessible unisex single-stall bathroom for use by an employee. Use gender-neutral signage for single-occupancy facilities. Employers must enforce dress codes in a non-discriminatory manner. Unless an employer can demonstrate business necessity, each employee must be allowed to dress in accordance with their gender identity and gender expression. Employers cannot deny employees the right to dress in a way that reflects their gender identity. Employees' request to be identified by a certain name or gender identity must be accommodated by employers unless there is a legally mandated obligation to use the employee's legal name or gender. Employers cannot require documentation as proof of sex, gender, gender identity, or gender expression as a condition of employment. Sexual harassment victims can be anyone in the workplace who is adversely affected by the harassment actions. It can occur between any employees regardless of their sex or gender. Often, there can be more than one victim, especially in situations where a hostile work environment is present. Harassment can come from many sources and even from outside the company. Managers, supervisors, co-workers, customers, vendors, suppliers, delivery drivers, contractors, and sales representatives can all be capable of engaging in harassing conduct. Sexual harassment can occur in almost every employment situation related to work. This includes whenever and wherever employees are fulfilling their work duties. It can occur at the workplace, on work-related trips, training events, business lunches or dinners, and even during work-related phone calls or video chats or conferences. If the situation or location is a direct result of employment, then sexual harassment is possible. Managers, supervisors, and other people in other supervisory positions must not engage in retaliation against any employee for filing a sexual harassment charge. Employees are legally protected by various federal and state laws. Retaliation is any action taken to extract revenge or punish an employee for filing complaints regarding sexual harassment or discrimination in the workplace. Actions which are protected from retaliation in relation to sexual harassment generally include informing the person designated by your company of harassment incident, filing a formal harassment complaint, assisting other individuals in making a complaint who have experienced harassment, providing information and/or testifying regarding a sexual harassment incident. Company policies on sexual harassment should be designed to encourage possible victims to come forward and should not create obstacles to complaints. Prevention should be the primary goal of the policy and is the best method to eliminate sexual harassment in the workplace. The policy should contain many issues related to harassment, which include strong statements which communicate to all employees that sexual harassment will not be tolerated, standards for appropriate dress, workplace behavior, and personal belongings like pictures, calendars, and magazines. Statements assuring employees the company will take immediate and appropriate corrective action whenever harassment has occurred. Names of appropriate personnel and departments to which employees can report possible harassment. More than one person should be designated to take complaints. Statements assuring total confidentiality, as much as possible, when dealing with harassment complaints. Language informing all employees that any form of retaliation against someone that brings a harassment charge or provides information will not be tolerated. Complaint or grievance procedures which provide a prompt, thorough, and impartial investigation. Remedies for the victim as well as disciplinary actions for the harasser. Corrective procedures to take to minimize any recurrence of the harassment. Anyone in a management or supervisory position has an obligation to take all steps required to stop sexual harassment. Management personnel must have a full understanding of the company policy and their responsibilities under the policy. Additionally, management personnel should always follow company policy and keep their actions above reproach, as their actions can cause a liability for the company. Set an example for all company employees regarding dress, actions, language, and relationship. Report any observed harassment or harassment which is reported to them, with no exceptions or favoritism. When allegations of sexual harassment are made, a prompt response is essential. Employers should determine if a fact-finding investigation is necessary. If the alleged harasser does not deny the accusations, then an investigation would not be necessary, and corrective action could be immediately taken. If a fact-finding investigation is necessary, it should be launched immediately and completed as soon as possible. Intermediate corrective measures to stop the unwelcome actions should be taken, and the well-being of the alleged victim must be secured at the very start. Steps such as scheduling changes, transfers, and placing alleged harasser on non-disciplinary leave with pay are some possible intermediate measures. The complainant should not be involuntarily transferred or burdened. Here are the steps of a fact-finding investigation. First, choose an investigator. The investigator in a sexual harassment investigation must be objective and trained to properly gather all facts. The alleged victim and harasser should not have supervisory authority or any direct or indirect control over the investigator. The investigator must also possess skills necessary to evaluate credibility and to interview all parties involved. The investigator will conduct interviews with all parties involved, as well as any witnesses. Many times, the interviews will produce conflicting versions of the incident. The investigator will need to determine the credibility of the various parties, and their assessment can be critical in determining if the harassment occurred. The investigator should gather any additional information that might help in the case. Items such as employment records, work schedules, time records, and emails are just some of the possible information that could assist in verifying facts for the case. The investigator will make an informed determination of harassment case. Once the investigation has been completed, the employer must decide if sexual harassment occurred. All parties involved should be notified of the decision. If due to inconclusive evidence and/or contradictions between parties, no decision is possible, the employer should still take preventative measures as a precaution and to reinforce the company's policy on sexual harassment. The company should apply appropriate corrective and disciplinary measures. If harassment has been determined to have occurred, employers must take appropriate actions. Corrective measures should be designed to stop the harassment, ensure that it does not happen again, and correct the effects on the employees. Corrective measures should be utilized to right the effects of the harassment on the victim. Measures should be designed to place the employee in the position he/she would have been had the incident not occurred. Examples of such measures might include an apology from the harasser, reinstatement, promotion, wage increase, replacement of time taken off, and correction of any other effect caused by the incident. Disciplinary action should be proportional to the seriousness of the incident. Minor issues might only warrant such disciplinary actions as an oral warning and retraining. If the harassment was severe or egregious, then stronger discipline would be necessary, such as suspension and/or termination of employment. Employers should remember that if the harassment does not stop, they could be found liable, but that overly punitive measures could be grounds for additional legal action by the harasser. Employers must make sure the punishment fits the crime. Possible disciplinary actions include training, oral and written warnings, wage reduction, demotion, transfer, suspension, and termination of employment. Measures taken should not affect the victim negatively. Corrective measures taken that penalize the victim could constitute unlawful retaliation. Any investigation must be documented. A written report should be kept of the investigation. All files should be kept confidential and only authorized personnel allowed to view them. These files might be needed should future harassment charges be alleged. As a manager, it is important that you are aware of your company's sexual harassment policy. Never ignore a sexual harassment allegation or actions. Sexual harassment is not a laughing matter and must always be taken seriously.